As the world was suffering in agony because of the evilness of the Dark Lord, the guardians of the Hogwarts realm summoned the Fellowship of the Freedom of Information Act to annihilate Lord Ravana by fulfilling the prophecy. All assumed Lord Ravana was immortal and invulnerable, but he was destined to a prophecy which could be the death curse of the Dark Lord. The prophecy reads that, as Malaysia enacts Freedom of Information Act, the Dark Lord will depart and be gone forever. The Fellowship was sent to Malaysia and the litigation was brought up in front of Chief Justice Dumbledore to decide whether Malaysia needs Freedom of Information Act or not. The Fellowship stands as the advocates of the issue, and the Dark Lord was called up to be the defendant. As the proceeding follows, the first member of the Fellowship starts her submission.
Till the last century, laymen, scholars, philosophers, and the majority tend to associate the concept of freedom lies only in the implementation of laws. This perspective restricts participation, conversation, political activity, or economic interest. However, due to the advancement of the humankind in the several decades, we have reached the point to extend the concept of freedom to combat acceptance of an individual of the limits, seen and unseen, that is imposed on him by the higher authority. The restriction does not come by the suppression of thoughts, but shaping of such by the master who hurt our mentality to a certain enclosure. Many recent events in our own country will be addressed further that will prove that public are influenced by media, the political and economical benefits of such a union which remain in the darkness as the background. The question is that, how can we solve such crisis? Lipinski and Brits discuss that access to information as a critical need in this information age, and a statute which provides freedom of information is the cure for such a disease. For years in Malaysia, the Official Secrets Act 1972, a powerful tool for the government to hide important information, and to a great extent, the indiscriminate use of the title secret is no longer a secret. Whereas in 1972 can be explained as the anti-ethical legislation against the FOI which are being advocated for. In brief, the law aims to ensure that any official government information act is not to be received or released without prior authorization, and the term official secret has been defined under Section 2B, which covers nearly all governmental documents. This is where the problem arises. In simple terms, how do the authorities classify a document as any of the aforesaid terms? What are the requirements and procedures? The answer for this question was explained by Muhammad Izam during a Bar Council forum. He sarcastically mentioned that there is no difference between vital information on corruption and the papers other than the stamp rasim. It readdresses the problem in classifying governmental documents and denies the basic right of citizens to review transparency of the administrative that is ruling us, which lead us to advocate for FOIA. Rather than addressing FOI as a mere political thought, it would be desirable to explain it in a legal concept, as the main core of the message is to advocate FOIA. Based on a journal article by Veera Mantri, the author conceptualizes access to information as ancillary to the right to self-governance. He attests the importance and aim for the FOIA by saying if self-government is a human right, it can therefore be similarly argued that access to information on which self-government depends is likewise a human right. The reason of such saying was that if self-government relies on the consent of the informed citizen, if there is no FOI, the citizens are not informed, so they cannot truly consent to be self-governed. Furthermore, it is a responsibility to fathom that the right information imposes obligations not only on government, but also on those who withhold information which an individual is entitled to receive. Thus, it's not an obligation to the government only, but also to private entities. As addressing the FOIA, it is imminent to look back at the Article 4 of the Declaration of Principles issued at the Geneva Summit, which proclaims that everyone has the right to freedom of opinion and expression, that this right includes freedom to hold opinions without interference and to seek, receive and impart information and ideas through any media and regardless of frontier. Everyone, everywhere should have the opportunity to participate, and no one should be excluded from the benefits the information society offers. This again affirms that The access to information should be viewed as an instrumental and basic human right as addressed by Brits and law. With all the background stories and reasoning, FOIA can be seen as a legal protection of the right to know about relevant and legitimate decisions of the government, private entities, and a policy tool which works for the betterment of the society. Referring to Birkenshaw, FOIA can act as a precondition for openness, transparency, accountability, responsiveness, and integrity of government. Before moving on to the need of FOIA, all should understand there is always two sides for a coin. If there's only one side, then it is meaningless. So the need will be addressed before the pros and cons of the FOIA. Practicality of FOIA will also be further addressed before a judgment is given.
The next member, please.
The Freedom of Information Act could be a landmark or a milestone of a Malaysian legal system, as it is now needed more than it was ever before. The reasons to have Freedom of Information Act will be addressed under four main ideas which will advocate the public on the need for a freedom of information regime in Malaysia. And before pondering into the case studies, the question which arises is, why does Malaysia need a Freedom of Information Act as our rights are protected under the prestigious Malaysian Constitution? The answers are as follows. Frankly, the bindings on the Act seems to find their roots in the Federal Constitution itself. It is true that under Article 10, subsection 1, subsection A of the Federal Constitution of Malaysia, every citizen has the right to freedom of speech and expression, but it is essential to understand that those rights are quantifiable and limited as Article 10, subsection 2 allows Parliament to impose restriction as it deems necessary or expedient in the interest of the security of the Federation or any part thereof, public order or morality, and restrictions designed to protect the privileges of Parliament or any legislative assembly or to provide against contempt of court, defamation or incitement of offence. In simple words, it allows Parliament to pass any laws which it deems necessary or expedient to restrict the freedom given by Article 10. Note that it does not have to be reasonable. For example, in the case of Civil Rasa Rahsia and Bar Council, the court ruled that the Parliament is the final judge of what restrictions to impose following the rule in Public Prosecutor and Pung Chen Chun. From the aforesaid statutes and precedents, it can be deduced that even a right given by the federal court itself is limited to a great extent. Imagine on a right which is not even been mentioned in a statute. Next, as to explain the need to have Freedom of Information Act, even there is hundreds of reasons to explain the importance and need of it, but due to time constraint, only four main ideas supporting the cases. Studies will be addressing the need meticulously. First and foremost, the first main idea which advocates for the need of Freedom of Information Act is to protect the environment and increase the safety of public from environmental disasters. At the end of 2009, there was a debate as to whether a report would be made public since it was classified under the Official Secret Act and needed cabinet approval to disclose it. This was challenged by the head of the region under the federal opposition, who went ahead and released it to the public despite the threats of being charged. In December 2008, landslide hit the area outside Kuala Lumpur, killing 5 people. Public needed to know about the classification of lands and forests, if they have been gazetted, the safety level, and as what the threats are. This helps with ensuring the safety of people. By stating the reports as secret, the first reaction is to deny citizens' right to know. It conceals the possible wrongdoings and removes the responsibility of accountability of authorities. Next, construction of dams and power plants with little public consultation. In 1998, construction of the Selangor Dam was said to be because of the rising demand of water due to the growing population in Selangor. Civil society groups were not given data to support such claims. The environmental impact assessment was also found to be suspicious as it was done by the company within the consortium awarded the project. Moreover, tracking taxpayers' money in the highway business. Since the first private concession highway in 1982, the public had a view if the agreement between the government and the private companies in 2009 showed concessions for more than 30 years with unfair compensation claims for the company of the government did not allow a tariff increase. Many contracts done in closed tenders are classified under the Official Secrets Act, including the agreement between the government and the water supply company. Also, the enactment of this act will allow journalists to have access towards original and true news rather than publishing bogus fake news in a way which causes rumors that are controversial. Plus, the enactment of this act could promote journalism where the link between the free speech and free press becomes undeniably strong. Finally, information control prevents economic stimulus. Special agencies created for economic crisis like the National Economic Action Council were unable to assist small businesses to kickstart economic activities due to refusal from the Economic Planning Unit to disclose data needed for the projects. Such experiences have been recorded regarding a study on the privatization of healthcare where the EPU refused to reveal details of the consultant doing the study and the scope of the study. This makes it difficult for planning, implementation and decision making for the policymakers and also for the citizens.
The next member, please.
With the meticulous research, many scholars and legal philosophers have admitted that the enactment of Freedom of Information Act could be a major development for the country by all means. The enactment provides extensive advantages for the society and the nation, where some can be highlighted in a bold way. The first advantage, which could be addressed mainly, is the FOIA could be an indispensable tool of productivity, notably in the civil service. Imagine level of efficiency and productivity would increase if minutes of meetings, policies discussions, research papers and other administrative documents can be retrieved. Theoretically, an employee, especially in a civil servant, is expected to serve the administration of the country with no room of illicit deals, slipshod work, but this is the desired model has been achieved or checked in regular basis. In a private entity, there's a higher checks and balances on the employee to assess his efficiency by subjecting him to target levels and efficiency tests. What about the civil service? We all could commonly hear the phrase, "It is after all the government," as people standing in long queues complaining the efficiency of civil servants in Malaysia, but FOIA could be the glaring eye that would alter the misconception. The entrenched perception that the government departments are generally slow, poor, and inefficient can be solved by FOIA. Many journal articles supports the view that inefficiency in civil service rise due to the lack of supervision, but with FOIA, it supervises the civil servants without the cost of a full-time supervisor. One must always be ready and efficient, as the checks can be requested perhaps a decade later or just the next day. In such cases, an ordinary civil servant will be more accountable to the people he serves rather than his superiors in office. The failure to enact FOIA will make rumor mongering and speculation as viable sources of news, and the media will tend to direct people in the wrong way. To sum things up, the FOIA will make the media to be responsible, and the public will not become the prey of television rating points. Moreover, with the enactment of FOIA, Malaysia can achieve true development. The central thesis at Marcia Sen clearly mentions that the freedom lies development, and the Nobel laureate asserts that in a country with free press and high accessibility to the information, there will never be despair and misery. The FOIA will reduce the government to be accountable, and due to the corruption reduction because of the enactment, that large amount of funds will be channeled to the development of the nation. For holistic growth and advancement, and FOIA, which truly confers upon the citizen the legal right of access to all information held by government, is the possible answer. Furthermore, the enactment of FOIA could be a major step in safeguarding human rights in Malaysia since 1946. FOIA was recognized as a fundamental human right, the touchstone of all freedoms which the United Nations is consecrated. In the case of Autonic AG and Switzerland, the judge ruled that FOIA is a right which applies to everyone, whether natural or legal persons, which include Malaysians, to also be considered. It is true that Malaysia is not bound by the ECHR or the rulings, but the principles advocated by its universal, and Malaysia deserves it too. The court further extended that the right apply not only for access to contents but also means of transmission of information, which are advocated by all fighters of FOIA. The FOIA is addressed in a human rights view because it was affirmed as one under the United Nations Declarations of Human Rights, which is one of the most important documents ever existed on human rights under Article 19. So it can be said that enacting FOIA, Malaysia can project itself sky high on the international stage as taking a step further in upholding human rights and fundamental liberties. In short, the enactment of FOIA will be one of the best legislation ever enacted in Malaysia, and by looking at the merits, it can provide and it is clear that the enactment should be advocated and passed by the Parliament for the betterment of the nation.
May the defendant arise for his submission.
Every coin has two sides. The Freedom of Information Act is not an anomaly for such a rule. The advocates of Freedom of Information Act highlights the advantages of the Act but purposely exclude the disadvantages of the Act to create a mirage in front of the public. As I'm standing here today, it is my responsibility to attest the adverse effects of enacting Freedom of Information Act. The disadvantages of Freedom of Information Act will be addressed using vital points to prove to the court that such act is not essential for Malaysia. Moreover, it could be detrimental to the country and the public. The first major point which I would like to address the court with is the hardship of drawing a line about which information should be confidential and which should be transparent. As the Malaysian civil system and also other sectors are bound by the legal constraints of Official Secret Act 1972 and Public Officers Regulations 1993 and other confidential provisions, there is no need for such a line which could be wrong after the enactment of Freedom of Information Act. In the absence of Freedom of Information Act, the government and authorities have more freedom in classifying the documents, which reduces the risk of information which should be confidential to be leaked out. But after the enactment of Freedom of Information Act, the authorities and administrators have to have a higher burden to supervise over the movement of the document to prevent public disclosure. As readdressing the Herculean task of drawing a line between which should be shared and which should not, I would like to cite an important speech from the former Attorney General, Yang Bahagia Tan Sri Dato Sri Haji Muhammad Apandi in 2016 affirms my claim on the disadvantages of Freedom of Information Act. The respected has mentioned that even though the mass desires for transparency, it is important to understand the importance of confidentiality in sensitive official informations. By enacting the Freedom of Information Act, it will be hard to secure such sensitive confidential informations because a new dispute arises saying which is sensitive and which is not. In the case of AG and Jonathan Cap Limited, the court addressed that every single information have different lengths of confidentiality and it only can be judged in a case-to-case basis. Furthermore, the court has to address and acknowledge the fact that even in open governments, there's a lot of exemptions which relieve itself from the Freedom of Information Act, such as national defense, personal privacy, and etc. These types of exemptions have also been addressed in the case of Bennett and President of HREOC, where the court ruled that confidentiality has a necessary role in the government system. This shows that confidentiality is a necessary aspect of a government and freedom of information is not an essential aspect which should be giving prioritize over the other values of the government. By the same token, I would like to address the disadvantage of Freedom of Information Act using the mosaic theory. According to D.E. Posen, the mosaic theory is the idea which solves a complex puzzle using seemingly insignificant pieces of information. In the case of US and Machete, the judge ruled that what may seem trivial to an uninformed person may be a great moment to someone who has a broad view of the scene and put it in the proper context. Additionally, in the case of AGN, Guardian Newspaper Limited, Lord Griffiths mentioned that the trivial information could be the last piece of jigsaw which sought by hostile intelligence agency which put the whole nation under the risk. According to C.E. Wells and my previous statements, as people getting easier accessibility to information due to the Freedom of Information Act, such information when assembled together could backfire the nation and the public safety. For example, after the 9/11 case in USA, several cases such as North Jersey Media Group and Ashcroft and some other cases mentioned and applied the mosaic theory in their ruling. Imagine this for a moment. If the court have applied mosaic theory preemptively, things could have been changed. And if Malaysia allows Freedom of Information Act without taking mosaic theory into consideration, we maybe ponder over the same guilt in future. Succinctly, starting from the hardship of having a line between which is confidential and not until the threat it gives to a country, basically Malaysia, the detrimental effect is higher than the benefit it could purport end of the day. So, as last words, the Freedom of Information Act should not be enacted, and I rest my case.
May the public representative come forward.
Practicality is very different compared to the theoretical model of a concept. After looking at the pros and cons of the enactment of the Freedom of Information Act, it would be desirable to look at countries which are practicing the Act for an insight about the practicability in the real world. By looking at different countries, it will provide a further understanding for us before concluding our support for the Act. Currently, based on the statistics given by UNESCO, there are 112 countries which have enacted the Freedom of Information laws, which we can look at, but due to the time restriction, referring to the UK and US, as well as the European Convention of Human Rights, also known as ECHR, would be sufficient to get an understanding over the implications of the Act. Firstly, the UK has the Freedom of Information Act 2000, which provides public access to information held by public authorities like government departments, local authorities, the NHS, state schools, and police forces. But this does not cover every organization that receives public money, such as charities, which receive grants, or private organizations that perform public functions. It does this in two ways. Firstly, public authorities are obliged to publish certain information about their activities. Secondly, members of the public are entitled to request information from public authorities. According to this Act, it covers any recorded information, such as printed documents, computer files, letters, emails, photographs, and sound or video recordings that are held by public authorities. Information held by Scottish public authorities is covered by Scotland's On Freedom of Information Scotland Act 2002. Both of these acts as two separate acts. Public authorities will only be subject to one of the provisions, but not both. The UK Act applies to public authorities in England and Wales as well as cross-border public authorities in Scotland. The cross-border public authorities are mentioned under the Scotland Act 1998, such as the Forestry Commission and the Food Standards Agency. Thus, while such bodies may be based or have offices in Scotland, they will be subject to the provisions of the UK Act. In the UK, according to Justice Minister Simon Hughes, between 2005 and 2014, more than 400,000 information requests have been made under the Act. There are several things that we would not have known otherwise, which shows the impact of this Act. Here are some examples. 1. Accident and ambulance delays. The recommended waiting time for patients to be attended by ambulances is 15 minutes. However, through the Act, it was revealed that the average waiting time is 20 minutes, while the longest waiting time recorded was in Wales, a record of 6 hours and 22 minutes. 2. In the 1992 exchange rate crisis, where the UK Treasury reported the dramatic but futile attempt to keep the value of the pound tied to the European currency exchange rates cost the UK government $3 billion, but it was in actual fact the reported amount is only a fraction of the actual amount. 3. The food hygiene ratings for hundreds of thousands of restaurants, cafes, and shops are now publicly available because of the Act. According to the ECHR, under Article 10, Freedom of Expression, everyone has the right to freedom of expression, and this right shall include freedom to hold opinions and to receive and impart information, as well as ideas without interference by public authority and regardless of frontiers. In Department of Health and Information Commissioner, the department had altered the way it reported late abortions to protect the identities of those involved. It was held that the disclosure would not have contravened the data protection principles, and consequently, the department was wrong to rely on Section 14 of the Act to withhold the disputed information. The Information Commissioner was right to find that disclosure would not be in breach of the abortion regulations, and therefore, Section 44 of the Act was not engaged, and by failing to disclose the disputed information, the Department of Health had breached Section 1 of the Act. In the US, the Freedom of Information Act also provides that any person has the right to request access to federal agency records or information, but only to the extent that the records are protected from disclosure by any of the 9 exceptions contained in the law, or by one of the 3 special law enforcement records exclusions such as classified information for national defense or foreign policy. In the Department of Justice and London, the Supreme Court of the US held that the government is not entitled to a presumption on that the source is confidential within the meaning of Exemption 7D of the Act, whenever the source provides information to the FBI in the course of a criminal investigation. In conclusion, looking at how others bring about and enforce the Freedom of Information Act, it makes a convincing stance that Malaysia should have it as well.
In conclusion, Freedom of Information Act is needed in Malaysia because of various reasons. The reasons include protecting the environment and increasing the safety of public from environmental disasters. The public should have access to the reports on the disasters that happen in Malaysia, so that they know which areas should be awarded to keep themselves safe. Next, freedom of information would ensure that the public in getting the information on government initiatives beforehand. For example, it is the right of the public to know if the government's initiatives or construction projects are closely related to them. Freedom of information can be used to prevent the government from hiding information from the citizens. The government should be more transparent on the decisions made related to the country. Moreover, the enactment of the Act can increase the growth of Malaysia's economy. Freedom of information increases the chances of new businesses to get information on government grants through the internet. One of the advantages of the Freedom of Information Act is the efficiency of workers will increase. Companies and other organizations can have access to the relevant information when conducting research, and it will be less time-consuming. Besides, the media will be able to reveal the true statistics and news. The media could stop reporting fake information in order to increase the television ratings. The next advantage is that Malaysia can move a huge step forward in becoming a developed country, as there are quite a few of the Western countries who had the Act. Malaysia can improve on these aspects of human rights so that the people's rights can be safeguarded. However, there are still disadvantages of having the Freedom of Information Act. One of the disadvantages is difficulties in identifying the information that can be open to the public or need to be kept in secret. The government may need to be extra careful when releasing information to the public, as there will be a larger possibility that confidential information may be leaked by mistake. Next, in some circumstances, the information that may be seen as unimportant could be a threat to the country. Even a small clue can lead to a general view of the whole picture. The information could lead the citizens of the whole country into danger if the information is obtained by undesirable parties. There are quite a number of countries which enacted the Freedom of Information Act, including the UK and the US. The freedom of information is very much related to the European Conventions of Human Rights. UK has the Freedom of Information Act 2000, which allows public to access the information of public authorities. The public was even allowed to request for information directly from the public authorities. The public has more opportunities to gain knowledge about the welfare benefits that are available to them. In the US, the Freedom of Information also let the public to have the right to request or access to the federal agency's information, but only to a certain extent, as some information can't be open to the public. There is some information that needs to be kept confidential to avoid the security of the country being breached. Based on the points that were mentioned previously, it is clear that Malaysia should enact the Freedom of Information Act. The Freedom of Information Act will not only protect the rights of the people in Malaysia, but it will also let the foreigners to have easier access to the information when they are in Malaysia. This will be more convenient and easier for them to adapt. By doing so, Malaysia will move towards achieving a better future for the Malaysian citizens and for the country as a whole. As the Malaysian Parliament agreed to the judicial reasonings of Chief Justice Dumbledore, the Malaysian Freedom of Information Act was enacted with the support of majority. As the Act passed both houses, the Dark Lord vanished and was never to be seen again. The Fellowship went back to Hogwarts for a new mission with a high sense of accomplishment.